Hey, I want to be real with you guys. You know, I usually film my videos about a week in advance. So right now, there's a ton of stuff going on with these Trump supporters that barged into the Capitol building. So it's going to be really hard for me to focus on this video today. I so wish I had you all in class. Nevertheless, I'll do my absolute best to stay focused. It looks like a crowd at Comic-Con. I mean, seriously, there's a dude dressed as Super Chief from DC Comics in the speaker's chair. Nope, focus. Cue the intro. So while the world is burning to the ground, let's learn about our civil liberties. Last week, we really focused on the First Amendment. This week, we're going to move on and start with the Second Amendment. Now, as you all know, the Second Amendment is a highly charged topic. And quite frankly, I'm actually a little happy that I'm not teaching this in class. Because whenever I do bring up the Second Amendment in class,
you'll never take my guns. You'll never take my guns. You want to talk about some mammals? You ain't seen nothing yet.
I hear you guys, but all I've literally said is let's talk about the Second Amendment today.
Before you ever take my guns, you'll never take my guns.
Okay, let's talk about some Supreme Court cases.
followed by the other half of the class saying things like,
I say we will not stop until every man, every woman, every child, and every American can live without fear of gun violence, and to that I say, no more.
Okay, cool guys, but why don't we dive into what the Founding Fathers meant by the word militia?
Thank you, I love you all, God bless all of you, and God bless America.
Yeah, and then my class turns into a scene straight out of the Ukrainian parliament. So you can understand why for the longest time the Supreme Court rarely, if ever, actually touched the Second Amendment. The first major court case to deal with the Second Amendment to reach the Supreme Court was D.C. versus Heller in 2008. And in that case, the court overturned a D.C. ban on handgun ownership for the purpose of self-defense within an individual's home. A couple years later, in a case called McDonald versus Chicago, which is one of your required Supreme Court cases for the AP exam, the court overturned a Chicago ban on handgun ownership. The right to bear arms, they said, is not less important than the other amendments. Justice Antonin Scalia wrote the majority opinion and said the Second Amendment protects a personal right to keep and bear arms for lawful purposes, most notably for self-defense within the home. McDonald versus Chicago actually applied through selective incorporation the Second Amendment to the states. That first case, D.C. versus Heller, wasn't involving a state since it's Washington, D.C. So that's why that case did not incorporate the Second Amendment to the states, but McDonald versus Chicago did, which is why that case is so important. Now, the judicial activists on the court, or the liberals on the court, argued that gun ownership had to in some way be tied to the militia and that the Second Amendment didn't guarantee a right for Joe Schmo down the road to purchase a pistol and keep it for self-defense. After all, the actual text of the Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The conservative originalists on the court, like Justice Antonin Scalia and Clarence Thomas, said, well, hold up. You don't have to be part of the militia to own a weapon for self-defense. That's not what the original intent of the Second Amendment was. The originalists on the court pointed back to the fact that when the Second Amendment was written, a militia was the people, the regular people in an area or in a state that had a weapon for self-defense that would be called up to defend the state if it was being attacked or threatened. The originalists relied heavily on what some of the Founding Fathers said a militia meant, like, for example, George Mason, who was asked, who is the militia? He said, who are the militia? Well, they consist now of the people, the whole people, except a few public officers. Richard Henry Lee also talked about how the fact that the militia was the people themselves. So the significance of McDonald versus Chicago shows that no state or city government can outright ban handguns. But what about other types of weapons? Can you own a bazooka? Can you own a tank? What about something kind of in a gray area, like an AR-15? That's a tough question society has been debating about so frequently over the last few decades. So let's ask Mr. Originalist, who actually spearheaded those opinions, what he thinks about that.
You wrote in 2008 the opinion in District of Columbia v. Heller, the majority opinion that said the Second Amendment means what it says. People have a right to bear arms. Question: how far does that constitutional right go? Can a legislature ban semi-automatic weapons, or can it ban magazines that carry 100 rounds without violating an individual's constitutional right to bear arms?
What the opinion in Heller said is that it will have to be decided in future cases what limitations upon the right to keep and bear arms are permissible. Some undoubtedly are, because there were some that were acknowledged at the time. For example, there was a tort called affrighting, which if you carried around a really horrible weapon just to scare people, like a head axe or something, that was, I believe, a misdemeanor. So, yes, there are some limitations that can be imposed. What they are will depend on what the society understood were reasonable limitations at the time. There were certain location limitations. What
about these technological limitations? Obviously, we're not now talking about a handgun or a musket. We're talking about a weapon that can fire 100 shots in a minute.
We'll see. I mean, obviously, the amendment does not apply to arms that cannot be hand carried. It's to keep and bear, so it doesn't apply to cannons. But I suppose there are handheld rocket launchers that can bring down airplanes that will have to be it'll have to be decided.
How do you decide that if you're a textualist?
Very carefully. My starting point and probably my ending point will be what limitations are within the understood limitations that the society had at the time. They had some limitations on the nature of arms that could be borne. So we'll see what those limitations are as applied to modern weapons.
Even though Justice Scalia passed away a few years ago, the court now has mostly originalists who adhere to Justice Scalia's originalist philosophy and will likely approach the case in the same way. All right, we're moving on now to the rights of criminal defendant. Now, before the Bill of Rights was added onto the Constitution did provide some protection to those accused and convicted of crimes. For example, there's an ex post facto clause. An ex post facto refers to laws criminalizing conduct that was legal at the time it occurred. So you cannot be punished for something if it wasn't illegal when you did it. There's also something in there about bills of attainder, and that's where a law is passed by Congress punishing an individual without a trial. Well, they're not allowed to do that. Congress is not a court. Remember that whole separation of powers thing. There's also a clause in there pertaining to writs of habeas corpus, and that's a document setting out reasons for an arrest or detention. The government must provide writs of habeas corpus unless there is a rebellion. And then there's stuff in there about procedural due process, and that's a judicial standard requiring that fairness be applied to all individuals equally. The first part of the Bill of Rights that deals with criminal procedure in any way is the Fourth Amendment. The Fourth Amendment states that the government must obtain a warrant before searching people or places, and a warrant is a document issued by a judge to the police authorizing a search. Now, in order to get a warrant, police have to have probable cause, and that's reasonable suspicion that a crime has been committed or that there is evidence relevant to a criminal investigation. So let's say someone breaks into a museum and steals something, and the police show up and they find some handprints and fingerprints. Well, in order to get a warrant, they first have to go to a judge and present their evidence. And if the judge thinks that there's a case to be made for a specific person to be searched, then the judge will say, all right, seems legit. They'll issue a warrant. Then the police can go search that person and the premises for specific things. They find enough evidence to actually carry out an arrest, and they can do that if the warrant allows it. But like I said, the warrant has to be specific and actually list the things to be seized and the places to be searched. So if you're accused of stealing a car, cops can't come into your house and start searching through your kitchen drawers. Yeah, even if they see something else illegal in their search, if it wasn't on the warrant, they can't seize it and prosecute you for it. Back in the 1960s, a woman in Ohio had her home searched as police were looking for a fugitive, but they ended up coming across child pornography. So they arrested her and charged her on child pornography, even though that's not what they were searching for, and that's not what was listed on the warrant. So in the Supreme Court case Matt versus Ohio, the Supreme Court established the exclusionary rule. Exclusionary rule is a rule that evidence obtained without a warrant is inadmissible in court. That means it can't be used against you in court. Now, the Fourth Amendment is not absolute. There are definitely exceptions to the Fourth Amendment, and generally speaking, there's about 6. First of all, if police are making an arrest or searching someone, they can pat them down and search them to make sure they're not carrying any weapons to protect the police officers. Secondly, and this is the most common way searches are done, Police may ask you to search stuff, and if you consent and say yes, then it's a perfectly legal search. That's why it's a generally good rule of thumb to say no. And number 3, cops can see things in plain view. If they see things in plain view, then they don't need a warrant to seize those things or search further. Number 4, stop and frisk. The Supreme Court has ruled that stop and frisk policies are okay. If a police officer thinks someone is suspicious and they have reasonable cause, they can stop and frisk them. Number 5, there's an automobile exception. If police see you speeding or if they smell marijuana coming from a vehicle, then sometimes the police can actually pull over the car and search it without getting a warrant first. And then number 6, exigent circumstances. Exigent circumstances is a fancy way of saying that there's an emergency and the police have to act immediately. For example, if they hear a woman yelling, "Oh my gosh, she's going to kill me," and bust in without getting a search warrant. Police smell marijuana coming through a door and they walk up to the door and ask to come in, and suddenly they hear a toilet flush, meaning that the evidence may be quickly leaving them through the drainage system. They can bust down the door and actually come in and search. The big controversy involving the Fourth Amendment today involves whether or not the government can look through your data on here without a warrant. I mean, is the data on here yours? Is it Apple's? Is it Facebook's? What if they give your data to the government? Do you have a reasonable expectation to privacy on here when you use this? Or does the National Security Agency, the NSA, have the right to collect data on here to try to protect us from terrorist threats? Are you willing to let the government snoop around in here without a warrant in order for them to potentially catch someone that might be planning an attack? It wasn't too long ago that former NSA employee Edward Snowden became a whistleblower by revealing the fact that the government was collecting bulk amounts of our metadata without using a warrant. Now, a lot of people said, well, if I'm not doing anything wrong, then I have nothing to fear, so I don't really care. But here's why Edward Snowden said maybe you should still care about it.
Why should people care about surveillance?
Because even if you're not doing anything wrong, you're being watched and recorded. And the storage capability of these systems increases every year consistently by orders of magnitude to where it's getting to the point you don't have to have done anything wrong. You simply have to eventually fall under suspicion from somebody, even by a wrong call. And then they can use the system to go back in time and scrutinize every decision you've ever made, every friend you've ever discussed something with, and attack you on that basis to sort of derive suspicion from an innocent life and paint anyone in the context of a wrongdoer.
That debate over security versus liberty and privacy rages on today, and Edward Snowden is not allowed back into the country because he broke that Espionage Act that we talked about that was applied to Schenck in World War I. Some people say Edward Snowden is a traitor for revealing that top secret information. Some people say that he's a patriot and a hero for revealing that the government may be acting illegally. Some people are even petitioning Donald Trump to use his power as president to pardon Edward Snowden before he leaves. Moving on to the Fifth Amendment, which has more protections for criminal defendants. The Fifth Amendment features due process protections for criminal defendants and starts off with the right to a grand jury. And a grand jury is a group of citizens who decide whether or not a person should be indicted, that means charged, on criminal charges and subsequently tried in court. So a grand jury is basically trying to see, is there even enough evidence to move forward with the trial against this person? The Fifth Amendment also protects against double jeopardy, and that protects an individual acquitted, that means proven not guilty of a crime, from being charged with the same crime again in the same jurisdiction. Now, this doesn't mean that if you allegedly commit a crime one time and the jury says that you're acquitted, you're not guilty, that if you go out and actually commit that crime another time, that they can't bring you up on trial for that other time as well. Also, if there's a hung jury, meaning a jury that doesn't unanimously decide that you're not guilty, then yeah, you can be brought back up again on those charges with a new trial. The Fifth Amendment also states that you have the right to remain silent and to have an attorney present during questioning. These rights have to be given by police officers to individuals suspected of criminal activity, and that was established in the case Miranda versus Arizona, which established Miranda rights. And that's the famous phrase you've all heard before.
You have the right to remain silent. Anything you say may be used against you in a court of law.
If police officers make an arrest and forget to read someone their Miranda rights, it can lead to a whole mess with the case.
She's going to jail this time.
I don't know about that.
And why not?
Apparently, Your Honor, our officers forgot to Mirandize her.
I was waiting for Miranda to come in there and nobody came in there. I was waiting for her. That's right, ain't nobody Miranda me. Miranda wasn't even in the room.
Excuse me?
We were fighting for our lives, Your Honor.
You forgot to Mirandize her?
That old woman got the strength of any man.
I've got to let you go.
You gotta let me go.
Now, there's a reason why this protection against self-incrimination is in there. We've all said stupid stuff or said stuff that might make us look guilty of something when we're really not. That's why the Supreme Court said in Miranda versus Arizona that police had to remind you of the fact that you have the right to remain silent. You don't have to say anything that might incriminate yourself. In fact, I've got time to show you a quick example of self-incrimination straight from Judge Judy, where this girl came on and accused these two guys of stealing her wallet.
What was stolen?
My wallet.
What was in your wallet?
It was $50.
Okay.
I had to replace all my IDs. I had gift cards in there, my earpiece, and a calculator.
There was no earpiece in there, ma'am.
I love it. Judging for the plaintiff for the amount of $500. That's what I think it's worth, madam. Goodbye.
So if you're ever on the stand someday accused of a crime, remember, you can say the famous phrase, "I plead the fifth." That's where that comes from. In fact, your defense attorneys will tell you likely to say, "I plead the fifth" if you're asked any questions by the prosecuting attorney.
I plead the fifth. Anything you say, fifth. Go ahead and ask me a question. Did you?
Now, if you're on the other side of a case, it gets pretty annoying when your side constantly asks the other side questions and you hear nothing but,
On the advice of counsel, I respectfully decline to answer and assert my Fifth Amendment constitutional privilege.
If you want to see what a world without these Fifth Amendment protections is like, where people vote to kill others based off of the most ridiculous and faulty evidence, just simply play the game Among Us. I can't tell you how many times I've been ejected from the ship because people thought I was the imposter, all because I reported the body and then forgot the name of the room it was in. Thank God that is not the model for our judicial system. One last quick point on self-incrimination. A lot of people think that if you're ever called to be a witness in a case, that you can say, "I plead the fifth." But the Fifth Amendment's protection against self-incrimination only applies to those who are being accused of the crime, hence the term self-incrimination. So if you're called to be a witness, you will have to testify. And that actually leads us to the Sixth Amendment. The Sixth Amendment involves trials, juries, and attorneys. The Sixth Amendment protects your right to a speedy trial. That means the government can't delay your trial on end to basically imprison you indefinitely till, I don't know, maybe you die. You also have to be tried in front of an impartial jury. If you've ever read To Kill a Mockingbird, you know what it's like for someone to be tried in front of a partial jury or a very biased jury. But the Sixth Amendment preserves the right to be tried in front of an impartial jury of your peers. The Sixth Amendment also involves the right to compel witnesses to testify in your favor. So you have the right for the government to force people to testify that might have favorable evidence that might help you. And you also have the right to an attorney if you can't afford one, in which case the state will provide you with one. In fact, that's one of the only examples of a positive right, which, if you remember, is a right to someone else's goods or services that can be found in the Constitution. But for the longest time, the Sixth Amendment's right to an attorney only applied to the federal government in federal cases. It wasn't until the 1960s that selective incorporation finally ended up applying this to the states in a case called Gideon versus Wainwright. This case involved a guy named Clarence Earl Gideon who was convicted of robbery. Now, a Florida court denied his request for an attorney, and so he ended up defending himself in court. Well, after he was convicted, he ended up appealing, saying the trial court violated his Sixth Amendment rights. I mean, he wasn't a lawyer, but he won his appeal. So in Gideon versus Wainwright, the Supreme Court ruled that the Sixth Amendment's right to an attorney applies to all of the state governments now, and that's actually one of your required Supreme Court cases. Then there's the Eighth Amendment, which protects you against excessive fines and excessive bail. And bail is an amount of money posted as a security to allow the defendant to be freed while awaiting their trial. Once you show up to the trial, then whoever paid the bail will get that money back. It's kind of like ransom. But according to the Eighth Amendment, bail can't be excessive, meaning if I steal a pen from an Office Depot, I can't be put on bail for like $1 million. The punishment has to fit the crime, and usually it's the judges that decide that. Speaking of the punishment fitting the crime, the Eighth Amendment also protects against excessive fines. Any of you that's ever gotten a speeding ticket know how that process works. But the Founding Fathers knew that the power to fine people was a power that had been abused many times in history. Kings and queens of yore loved fines because it was an easy way for the government to get lots of money without necessarily taxing the entire general populace. Even today, governments still like to try to pull it off.
Dunedin, Florida wants to take this man's home.
Because I was tardy cutting the grass.
Jim Ficken's mom died, so he went to South Carolina to take care of her estate. City officials then started fining Ficken $500 a day because his grass had grown longer than 10 inches. Such fines add up.
This is a letter from the city attorney demanding $24,454.
Now the fine's up to $30,000. Ficken doesn't have $30,000. The city says it will foreclose on his home to collect the fine.
City Attorney of Dunedin in the last year has sought permission to foreclose on 18 properties.
That violates the Eighth Amendment, says the Institute for Justice. It not only protects us from cruel and unusual punishment,
but right next to that in the Eighth Amendment is a protection to be free from excessive fines. Our founders, they recognize that the ability to fine is the ability to cripple. And it's one of the ways, other than incarceration, that government can really oppress.
If governments can, they will. So we should be grateful for the Eighth Amendment. It protects us from excessive fines. And what's more excessive than politicians taking your home because you didn't cut your grass?
But hey, because this guy knew his Eighth Amendment, he got the Institute for Justice to help him out with this case, and just last year they won their first round in the court system. Now, the Eighth Amendment also protects against cruel and unusual punishment, and that's been a little tricky when it comes to the death penalty. In 1972, the Supreme Court said that the death penalty was unconstitutional, and they banned it in a case called Furman versus Georgia. But only 4 years later, mostly the same court in Gregg versus Georgia overturned that ruling and said, actually, it is constitutional to use capital punishment. They ruled that capital punishment is not cruel and unusual, but certain methods and situations could be restricted. Now, this is where a lot of people criticize judicial activists on the Supreme Court and their idea of the evolving Constitution as being just wildly inconsistent and far too subjective. Within the span of the last 50 to 60 years, what the court has said about the Eighth Amendment has been wildly inconsistent. It used to be that the death penalty for anyone below 16 was unconstitutional, then it got raised to 18, and then potentially it's going to be raised to 21 someday. Sometimes it's hard to figure out if and how much society has progressed. They also banned cruel and unusual punishment in the Eighth Amendment, and they had plenty of stories from history to kind of help develop that. Whether it be King Philip IV of France torturing the Knights Templar until they confessed to heresy so he could execute them, get rid of the debt that he owed them. I mean, there are a ton of examples in history of governments using torture to get false confessions from people to use as evidence to just get rid of them. King Henry VIII, the Spanish Inquisition.
Nobody expects the Spanish Inquisition!
I mean, governments did some awful things to people that I'll spare you the gory details of in this video. Now, with that said, our government does actually torture suspected terrorists at a base in Guantanamo Bay, Cuba. Foreign terror suspects are often taken to Guantanamo Bay to be tortured so that the government can try to get information on how to capture other terrorists or how to stop a potential terrorist plot. Critics have argued that this violates the Eighth Amendment's protection from cruel and unusual punishment and the Geneva Convention. But those that defend the torture argue that these aren't U.S. citizens. Therefore, since they're foreign terror suspects, the Eighth Amendment doesn't apply to them. Plus, it's not being done on U.S. soil. Speaking of controversies, that leads us to our last required Supreme Court case for this week's lesson, called Roe versus Wade. And to understand Roe versus Wade, we've actually got to go back to another case called Griswold versus Connecticut. In that 1965 case, the Supreme Court ruled that the Constitution protects the right to privacy. They overturned a Connecticut law which prohibited the provision of contraceptives and medical advice about contraceptive techniques. They argued that the Bill of Rights implicitly protects privacy through the First, Third, Fourth, and Ninth Amendments. The word privacy is not actually found in the Bill of Rights, but through cases, the courts have kind of determined over time that the meaning is implied in several amendments. Over time, this concept has been expanded to beyond contraception issues and into more intimate things. Lawrence versus Texas in 2003 was a case that struck down a Texas sodomy law making same-sex sexual conduct illegal. The argument was that there is a right to privacy that doesn't only include freedom of thought, belief, and expression, but also certain intimate conduct. It was in 1973 that the issue of abortion came to a head in the case Roe versus Wade. That case featured a woman named Norma McCorvey, who lived in Dallas, Texas, and filed a lawsuit against the district attorney of the county. She was wanting to get an abortion and wanted to strike down a Texas law which criminalized the act. She wanted a legal abortion, but she couldn't get one because her life was not in jeopardy, and she could not afford to travel to a state where it was legal. The ruling stated that the Constitution protects a woman's right to obtain an abortion in the first 3 months of pregnancy. It's called fetal viability, and that there is a right to privacy when it comes to abortion. However, the Supreme Court also ruled that states had a perfectly fine interest in banning abortion past the fetal viability period of that first 3 months. Now, this is probably the most controversial Supreme Court decision maybe ever. Opponents of the court's decision argued that it violates their deeply held religious conviction that terminating a pregnancy is murder of the unborn. Legally, they argued that you can't find a right to abortion in the Constitution. For almost 200 years, the issue of abortion was left to the states because of the 10th Amendment. They also argue that if you're going to use the 14th Amendment of the Constitution to say that there's a right to privacy that's not actually specifically listed in there, then you could also use the 14th Amendment to say that life, liberty, and property cannot be taken away without due process, and that allowing abortion is taking away someone's right to life, even if they're unborn. Proponents of the decision argue that women should have the right to choose whether or not to terminate a pregnancy, and that it's a private issue that the government has no business sticking its nose into. Legally, they're arguing that a state's ban on abortion is taking away someone's right to privacy without due process, and that therefore violates the due process clause of the 14th Amendment, which states that you cannot take away someone's life, liberty, or property without due process. It doesn't specifically say privacy, but it probably fits under one of those three things. So tensions run high with this case because each side believes that they have the moral high ground, and the legal arguments in Roe versus Wade are really in-depth and a lot more complex than what I just did scratching the surface. Now, Roe versus Wade has the chance to be overturned with an originalist majority on the Supreme Court now, but it's pretty hard to overturn precedent. Usually courts decide not to take up a case involving a subject the court has already ruled on, unless they feel like there's a need to revisit that. Most of the time, the court defers to stare decisis and precedent. What are the chances the conservative majority we have on the Supreme Court now decides to take on a case involving abortion and potentially overturn Roe versus Wade? I don't know. Remember, the majority of the Supreme Court that made the decision in Roe versus Wade was actually appointed by Republican presidents. So you just never know. But the idea that you have a right to privacy when it comes to health could have long-standing consequences if the government decides they're going to try to make, I don't know, the COVID vaccine mandatory. Might there be a lawsuit that says that your right to privacy also includes your right to refuse not to take the vaccine? If so, the court might have to balance what the government's interest is in trying to make sure the population is vaccinated versus an individual's right to privacy when it comes to their health. That would be interesting. And so that wraps up Chapter 8. So as for your assignments this week, you've got this Ed puzzle, and then just like last week, you've got a collection of perusal videos that go over the required Supreme Court cases you need to know. We'll discuss those a little bit more in depth in the perusal annotations, and then finish your outline on Chapter 8. That'll be due on Friday. Since we're finishing out Chapter 8, and there were a lot of required Supreme Court cases in this chapter, and there still are some more in the next chapter too, I'm going to post a link to all of the Oyez articles of these Supreme Court cases. Trust me, in my own experience in grad school, Oyez is a big help because it provides the issue, the questions at hand, how the court ruled in very simple to understand terms, and then it also breaks down how the court ruled in terms of their ideology. You can see who voted what on each issue. Then you can click on the oral arguments and listen to those as well. So use the links I put on there to Oyez to help you fill out that note chart on these required Supreme Court cases, and I'll post the link to that note organizer thing for the Supreme Court cases on that post too, in case you need another copy or a few. Well, that'll do it for me this week. I got to get back to watching the news to see what the heck is going on. If by the time you guys are watching this video and you have a better idea of what's going on than I do currently right now, feel free to email me questions and I would love to talk to you guys about it. Who knows, if enough people email me, maybe I'll just post a discussion board on Google Classroom. We can all kind of talk about it, share our thoughts on what the heck is going on. So keep your eye on the news and have a great week.